Got my eyes straight ahead, got my head in the game. With the red light on, I'm just waiting for the change. Keep my head down low.
So I was following up, looking for more information on the ex-police officer, the former police officer who tasered the elderly lady, 95-year-old Claire Nowlands, tasered her. She fell, hit her head. She ended up dying a week later, and yet he was not given any jail time whatsoever. He was not jailed when he was sentenced in March of 2025. Instead, he received 2-year community correction order. They referred to it as a CCO, and 425 hours of community service. So they appealed the case, obviously, and they had 4 grounds in which they appealed, including that the sentence was manifestly inadequate. So in the judgment, which I was reading about, it says the Court of Criminal Appeals said a CCO rather than jail time was appropriate in the case, though lenient. They've acknowledged it was lenient, saying plainly enough, there will be many cases where a CCO is not an appropriate form of punishment. No penalty other than imprisonment is appropriate, the judge read. His Honour did not consider that the present was such a case. That conclusion was, in my view, open to him, and is not one in respect of which this court would be justified in interfering, even though accepting that it fell on the lenient side of the spectrum. So, just in case you don't know, Mrs. Nolan, who was 95, she'd been wandering the halls and rooms of the home. She was in her own home at an old people's home, initially holding 2 knives. In walks police officer White, Christian White, who was with another police officer and paramedics. They found Mrs. Nolan in a nurse's room with 1 knife and using her 4-wheeled walker. Within the space of 3 minutes, White had asked Mrs. Nolan to stop moving, dropped the knife before he said, "Bugger it," deployed the knife. So she's hit her head. She died in Cooma Hospital a week later. So Director of Public Prosecution Sally Dowling presented her case last month before Chief Justice Andrew Bell, Justice Anthony Payne, and Justice Natalie Adams in the New South Wales Court of Criminal Appeal, arguing that Supreme Court Justice Ian Harrison erred in ruling White should not serve a prison sentence. So she's argued that White's actions did not fall at the lower end of objective seriousness, considering Nolan's age, disability, and frailty, and that general deterrent should be more strongly considered. So the barrister for White argued that the appeal should be dismissed, stating White held an honest belief that what he did was necessary to meet the threats Mrs. Nolan posed, and that the limited weight given on general deterrence was appropriate. In its judgment, the Court of Criminal Appeal agreed with the sentencing judge's observation that general deterrence had a minor role. General deterrence will typically have a lesser role to play in a case where no premeditation was involved. We do not live in a perfect world, and errors of judgment, even ones as tragic and significant as that which occurred in this present case, regularly happened. The court also found that sentencing judge Justice Harrison appropriately took into account the profound impact Mrs. Nolan's death had on her family and the community. His Honour's judgment endeavoured to explain with utmost sensitivity and clarity the complex task he was undertaking and the competing considerations with which he was obliged to grapple. I read all this, I was reading through it all, and you know what? I've come to the conclusion is that all they're saying, all these so-called justices, these intelligent, educated people are saying, is that if you are an elderly person who is she suffered from dementia, she was elderly, she could barely walk, she was moving with her walking frame. If you are an elderly person, well, then you are not as valuable. Your life is not worth nearly as much as someone else who is younger, living in their own home, can get around. She was in her home. She was in that nursing home. She was walking around with a walker. She had dementia. She should have been safe. But all this judgment says is that your life is not worth anything. You are 95. You could be expected to die soon anyway, so we don't really care. In Australia here, if you're an unborn child, we don't really care about you because you're allowed to be killed all the way up till birth. And now, if you're an elderly person and a policeman comes in, tases you, you hit your head and hit your head and die in a week's time, well, you're old. You know, it can be expected. Your life is not nearly worth as much as someone else's. That's all, to me, that's all this judgment says. Your life and the life of an elderly person is not worth nearly as much as a young person's life, as that police officer's life who took the other person's life in his stupidity. Remember, he was not supposed to. A police officer in Australia is not supposed to. You're trained that you're not supposed to draw a taser and use it on a person of that age. That is police procedure in this nation. He went against everything that he was trained to do, and yet they still said, no, her life was not worth as much as him spending time in jail. Her life was not worth anything. Very, very disappointing. This is just my opinion. I think these judges are wrong, and they are, in my mind, absolutely disgusting. But that's just my opinion. Let me know what you think. I'm Jay Fallon. We're on a slippery slope where there is no justice in Australia.
They just fuel a desire that will take me high.